Do you know that when a sheriff fails to enforce the writ of possession or the failure to force the occupants to leave the property can be penalized by the court as a simple neglect of duty? That is according to one administrative case of a sheriff I am going to share with you, the administrative case AM number P-22-054. What would be the penalty of the sheriff that was found guilty by the Supreme Court of simple neglect of duty? Let's find out in this article. Complainant Nalada filed an administrative case against Sheriff Gomez for failure to force the occupants to leave the property, to deliver it to complainant Nalada as a winning party in the legal dispute. When the sheriff was given a writ of possession, he had the duty to enforce this decision to expel the occupants from the property, and this property should then be delivered to the winning party. Why did the sheriff fail to enforce the said writ? Here is the story. The municipal trial court issued the writ of possession, giving the occupants 15 days to vacate the property before forcing them to leave. After 15 days, the occupants did not vacate the property, so the court issued the second and the final writ of possession giving the occupants 3 days to vacate, or else the sheriff should have to expel them. As evidence of returns of service submitted by the sheriff to MTC, the sheriff tried to enforce the writ twice, but was unsuccessful. After 6 months, the MTC issued another order declaring the writ of possession still stands, but 3 months later, the sheriff submitted another return of service, failing to expel the occupants that still occupied the building. In this case, complainant Nalada filed the complaint against Sheriff Gomez. A few years later, the decision came which found the sheriff guilty of simple neglect of duty, defined as a disregard of, or a failure to give proper attention, to a task expected of an employee. Sheriff Gomez was fined the amount of 18,000 pesos. Why did the sheriff fail to enforce the said writ? The only apparent information provided by the court was that the sheriff retreated when the occupants showed him the contract to sell. The sheriff's decision to retreat from expelling the occupants exceeds the role assigned to him by the court. The duty of the sheriff is purely ministerial. That means he must not have the power to choose whether he would execute the judgment by the court or not. His duty is to execute the final judgment of the court. By retreating, he chose to disregard the court's order to implement the said writ. This action is ultra vires or exercising beyond his power granted to him by the court. The failure to implement the writ of possession on multiple occasions was not justified. Sheriffs should know that they have the responsibility to serve writs of execution with reasonable speed. It is their ministerial duty to execute them with speed in accordance with their mandate. They should not be delayed. The victory of the winning party becomes empty if the decision of the court will not be enforced. The integrity of the administration of justice is affected if sheriffs did not perform their duty by implementing its orders, such as serving the court's writ and processes. There is no statement in this administrative case decision with which office the complainant filed the administrative case against the sheriff, but the complainant could have filed this with the office of the court administrator. These findings of the Supreme Court were published on November 11, 2022. However, upon reading the entire text of the case AM number P-22-054, it appears that this decision could have been published earlier, as of June 20, 2022. So the duration from the filing of the administrative case, which was on January 3, 2019, to the decision by Judicial Integrity Board or Supreme Court could have taken as long as 3 years. The first issuance of writ by the MTC granted the occupants a 15-day period. The second and final issuance of writ granted the occupants a 3-day period. The complainant must have filed a motion for the issuance of another writ of possession prompted the MTC to issue an order declaring the writ of possession still stands. The sheriff was required to submit a return of service on every issuance of writ by the court. In this example case, the sheriff took 4 months to submit a return of service from the first issuance of writ, 2 months from the second writ, and 3 months from the last order of the court. It could also be allowed for the complainant to request a copy of the returns of service submitted by the sheriff to monitor the progress of the case. Do yourself a favor and read the Code of Conduct for Court Personnel.